As the court pleases, my lady, I think we all here, Ms. Hofmeyer is here, Ms. Blizzard is here. So
My
I'm not sure if your ladyship's registrar wants to call the matter or whether we should just start.
Good morning, my lady. As the court pleases, my lady, this is a matter between the Special Investigating Unit and one other versus Mr. Zakhele Ezekiel Thabo Lebelo and 7 others, case number GP 06 of 2022, appearing in the Special Tribunal of South Africa before Madam Justice Modiba, 29 July 2022. My lady.
Thank you. Counsel may place themselves on record.
Good morning, my lady. Apologies for my slight delay. It is Kate Hofmeyer appearing for the applicants, together with my learned friend, Ms. Blizzard.
Thank you.
As the court pleases, my lady, Donna du Plessis for the first, second, third, fifth, and sixth respondents, as it pleases you.
Thank you.
Thank you, my lady. With your leave, if we may commence today's proceedings.
Yes, you may commence. I have had the pleasure of reading your thoroughly prepared papers and your comprehensive heads of argument. So it's not necessary for you to traverse the detail.
Yes.
And the issues for determination are well defined and quite narrow.
Thank you, my lady. We're indebted. We hadn't planned to even traverse the heads in great detail, but rather to use today's argument to respond to what was presented in my learned friend's heads of argument, because that is something that came in after we filed our heads of argument. But my lady, with your leave, I'd still like to structure the argument today in the same manner that the heads of argument were structured. And my lady, that was in 3 parts. I propose today to deal first with just the general approach that we submit the tribunal should adopt in today's proceedings. And then secondly, I will deal with the 2 contentious orders, the ones that require determination today. The first you will have seen in our heads of argument we refer to as the curator order, and the second thereafter you will have seen we refer to as the pension order. So it's my proposal to structure the argument in those 3 parts today. My lady, if we deal first at the level of the general approach, it is important to emphasize at the outset that the relief that the applicants seek today is relief of a limited duration. It is effectively relief of an interim nature, because it is relief which, if granted today, will only be in existence unless and until confirmed on the return day. If confirmed, it will have longer duration, but if not confirmed, it is the quintessential holding order that our law has described the utility of the process of a rule nisi fulfilling. It's a holding order that preserves the status quo. And my lady, the other important point we submit about today's proceedings is that all you have before you in order to determine whether that provisional order should be granted are the founding papers. There is no allegation in those founding papers that is disputed before you today. That is a process that will come in due course when the respondents are granted their full procedural rights to answer this case, to explain why on the merits the interim orders should not be confirmed, and to address in due course at a full hearing what their argument is in relation to those interim orders. So, my lady, the point for today's purposes and the approach that we submit this tribunal should take in deciding whether to grant the curator and the pension order is that they are quintessentially designed to maintain the existing status quo. They are designed to work together with the preservation order, which prevents the dissipation of the assets of the respondents, in respect of which the applicants say in due course they will have rights of recovery. They are designed to prevent the diminution in the value of those assets on a temporary basis, and they are designed to prevent payment of pension benefits to Mr. Lebelo on an interim basis, while this case for recovery is brought and concluded. So the relief sought today has no more than a holding effect. It takes the state of play on the day before this application was launched and simply requires that that state of play be maintained for a period of time. My lady, we also say that at the level of approach, it's important to place this case in its proper context. My lady, you will have seen in the founding papers that that context is the following. The applicants have shown that Mr. Lebelo and Mr. Mashamba used their positions at Transnet to enrich themselves. The case made by the applicants is that they took secret profits for themselves. They accepted bribes and other gratifications from two service providers of Transnet who they were in a position to unduly benefit in their dealings with Transnet. And my lady, we say that the general approach should also take the purpose of the tribunal's rules properly into account. These orders, if they are granted today, will operate immediately. They will preserve the applicant's rights in due course to get proper recovery if they can make out their case against the respondents, but they protect the applicant's position in that regard. And they do so in a way that in no way compromises the respondents' rights going forward, because they will be fully entitled to ventilate their opposition to this case in the months that come. So, my lady, we submit that the relevant question, my lady, sorry, your image has frozen on my side. I just want to be certain that you could still hear me.
I can hear you loud and clearly.
Thank you, my lady. So we say that the only relevant question before the tribunal today is whether a case has been made out in the applicant's founding papers for an order to preserve the status quo. And my lady, I understand that we're in agreement with our learned friends on that question. They don't put up anything to dispute the facts in the founding affidavit. They say they will argue this case only on the founding affidavit. They don't, for example, come before you today and make all sorts of other undertakings regarding how they're going to maintain their properties, that they're going to continue to pay their bond liabilities and their rates and taxes. They've done none of that. They gave undertakings in relation to dissipation of the property, but they don't come before you today to say that there's any reason not to be concerned that maintaining the value of the property should be in place in the next few months. So, my lady, if I may then move to the second topic for today, which is the curator order specifically. My lady, we began in our heads of argument, and I'm now at page 7 of those heads, with just a summary of the tribunal rules that have been designed to facilitate the type of case that the SIU Act is really concerned with. My lady, you'll well know that Section 2 of the SIU Act covers broadly the types of investigations that the SIU can be mandated to undertake. And at the essence of those investigations are concerns about unlawful acts which have had an impact on the public purse, the perpetration of criminal acts of corruption and fraud which have a civil consequence for the public sector, and then rules and a scheme designed to facilitate recovery when that misconduct has occurred. Now, it's against that legislative background that we say the rules that have been developed by the tribunal facilitate the proper work of the SIU, facilitate the proper work of civil recovery that the Act is designed to achieve. And it does that, the rules do so by permitting a range of orders. And many of them are designed on an interim basis to protect the ultimate position of those in the public sphere who have been affected by the misconduct that the Act is concerned to unearth. On the one hand, the rules facilitate preservation orders of the type that have been agreed to and which will not occupy us today. But the rules also allow a range of other things to happen to protect the position of the applicants in such cases. There can be a seizure of property to protect their interests. There can be, amongst other things, an appointment of a curator to ensure that once the property is preserved against dissipation, it is also not substantially reduced in value. And my lady, this is a point I'll come back to in a moment, but its importance bears reference here. It's one thing to interdict people from not selling or disposing of their property, but if that property is the very asset that is ultimately going to allow recovery on the part of the applicants, then it is equally important that the value of that property is maintained in the interim, because all sorts of perverse incentives start to come into play when property is the subject of a preservation order. Those who were once interested in the value of that property may not be anymore. They may see the threat of forfeiture at the end of the day as being sufficiently troublesome that they don't invest in the properties or maintain them. And it's precisely because of that reality that this tribunal's rules recognize that there may be circumstances in which a curator must be appointed. Now, my lady, we reference in our heads of argument the Supreme Court of Appeal decision in the Ngombe Zulu case. You'll find that at page 8 of our heads of argument. My lady, we commend that to your attention because although it is a judgment of the Supreme Court of Appeal dealing with a curator in the context of poker, the provisions and the similarities with the tribunal's rules are marked. And the point that we emphasize there is in Justice Turon's judgment in Ngome Zulu, where she points out that it is the pivotal responsibility of a curator bonus to ensure the preservation of the property, which is subject to restraint. And it is that against that backdrop that we say your ladyship will approach the question whether to order the appointment of a curator in this case. Now, my lady, we submitted at the outset that the question before you today is whether the founding papers make out a case for a curator to be appointed to preserve the value of the properties. And we do so against the backdrop of the facts set out in detail in the founding papers about those properties. It's important to remember what the founding affidavit says about those properties. These are two sets of immovable properties owned by the respondents that were purchased pursuant to payments received from service providers of Transnet. On one occasion, the property was wholly purchased by the more than 4 million rand paid to the Lebelo Trust. And in the other instance, in relation to the Mashamba's current immovable property, that property was in substantial part purchased through the funds derived from unlawful activities, as the allegations are made in the founding affidavits, pursuant to benefits given by the respondents to service providers of Transnet. Now, my lady, the respondents resist the curator relief on the basis that our papers, the applicant's papers, do not justify that relief. And so I'm going to spend some time in the papers taking your ladyship to precisely where the orders are justified. But my lady, our learned friends also assisted us in one respect, and that is by referring to the Commissioner of SARS versus Van der Merwe case in their heads of argument. My lady, we are indebted to our friends for that, because that case actually sets the test, we say, at the right level. My lady, if you consider that judgment and the point made about it in the heads of argument of the respondent, you will see that the court in that case, dealing with the appointment of a curator bonus, said that there are really two questions that a court, and we say, or this tribunal, will ask itself. The first question is, are the applicant's concerns legitimate concerns? And if they are legitimate, will the appointment of a curator assist in resolving those concerns? So my lady, we take our learned friend's invitation, and I propose to show you, as I go through the papers, both that the papers clearly show that there is a legitimate concern on the part of the applicants, which can be properly addressed by the appointment of a curator. My lady, the facts, I don't suggest we go to the founding papers unless strictly necessary. I'll take your ladyship through what is said there. But the first relevant part is in the founding affidavit at paragraph 30. At paragraph 30, the chief investigator of the SIU who deposes to this application, Mr. Theron, says the following. He says that in the SIU's experience, it is often necessary to appoint a curator to ensure that preserved property is maintained in a manner that will allow for the maximum recovery in due course, should the property be forfeited to the state. And the papers make it clear that forfeiture will be the ultimate objective of the applicants in this case. Now, my lady, as I highlighted earlier, these types of orders are generally necessary because once there is a prospect of future forfeiture of a property, there is a real risk that those who own them will not continue to invest in maintaining them. It's as though they've got a sword hanging over them, and there is consequently an incentive not to continue to invest in properties over which there hangs this risk of forfeiture. And that is why Mr. Theron goes on to explain that a curator is appointed and given powers to ensure, amongst other things, that the property is kept in good standing with the local municipality or homeowners or others associations, and is given power to take care of the property and to protect the property. Now, my lady, the respondents say that those allegations are too general. They're not specific enough. Our response to that is twofold. The fact that propositions are general do not undermine their force. They are general statements, but are statements made by a chief investigator of the SIU, speaking about the general incentives that apply when property is preserved with anticipation of forfeiture. They are the reasons why these rules of the tribunal recognize the need for curators to be appointed, and they refer specifically to Mr. Theron's concerns in this case about the diminution in value that may follow consequent to the preservation order in this case. But my learned friend is incorrect when in his heads of argument he says that those are the only averments in the founding affidavit justifying the curator order. That is not so. There are very specific averments about the fears that the applicants hold about the conduct that has been and may be perpetrated by the respondents. And my lady, you will find those references at page 166 of the papers at paragraph 265. And my lady, it may just be useful to go there. Sorry, 269, I do apologize. No, 265. Sorry, I was moving between two different parts there. So, my lady, if we pick it up at page 166 of the papers, paragraph 265. My lady, what you will see there in the section dealing with the requirements for an interim interdict are the applicant's real concerns about how the respondents will deal with their property. The following is said by Mr. Theron. There is a real likelihood that Mr. Lebelo and Mr. Mashamba will not preserve the property or the money that they received in secret profits and kickbacks for the following reasons. First, both Mr. Lebelo and Mr. Mashamba have conducted themselves dishonestly in their dealings with Transnet. They have both actively sought to conceal their secret profits. Mr. Lebelo, it goes on to say, did so by receiving property through a family trust vehicle. And in the case of Mr. Mashamba, this took the form of payments to a conveyancer, and then payments to a company owned by his wife, and then a combination of the two, ultimately to secure the property. The paragraph goes on. It talks about Mr. Lebelo's dealings in relation to his pension, which we won't occupy ourselves with now because I'll come back to that in a moment. But then it goes on at paragraph 625.3. The deponent says Mr. and Ms. Mashamba have also recently disposed of the Diepsloot and the Beverly properties and transformed those ill-gotten gains into new properties for themselves. They also, says Mr. Turon, went on an extraordinary spending spree after Eva Looks, that's the company owned by Ms. Mashamba, received its payments from the Transnet service provider, BBDM. And my lady, then reference is made to earlier in the affidavit where those spending sprees are detailed with some supporting documents. My lady, I will just give you the reference if I may. I don't suggest we need to go there, but you'll find that at page 151, paragraph 241.4 of the founding affidavit. What is set out there in detail is that after Eva Looks received in the order of 3.5 million rand from BBDM, there were purchases made to refurbish a kitchen, there were purchases made of furniture at Backhouse Brothers, and there was more than R500,000 rand paid directly to Mr. Mashamba. Now, my lady, we submit that those facts, set out in great detail in the founding affidavit, tell us the following about the respondents. They tell us that we are dealing with individuals who conduct themselves dishonestly, that we are dealing with individuals who do not have regard for their legal obligations, and we are dealing with individuals who are unrestrained in their utilization of their ill-gotten gains. And my lady, when those facts are put together with the more general facts about the SIU's experience when property is preserved in proceedings like that, like this, we submit we can answer those two questions in the Commissioner of SAR's case affirmatively. The questions were, are the concerns of the applicant legitimate? Certainly they are. They are dealing with respondents who have conducted themselves in ways that make their conduct questionable, in respect of whom there's no guarantee that they will continue to maintain these properties at a value that will allow proper recourse. And is the appointment of a curator going to be of assistance in resolving those concerns? Again, we submit the answer is certainly yes. A curator steps in, and because of his oversight powers, he ensures that bond repayments continue to be made, that rates and taxes are paid, and that the properties themselves are not allowed simply to devalue over time. My lady, we submit that we need go no further in this case than answer those two questions affirmatively. But I would, in conclusion of this point, just like to point out the extent to which the applicants did actually go further. The applicants thought seriously about the implications of this order for the respondents, and it is for that reason that they carved out a protection that would permit the respondents and those who occupy the properties to remain in occupation so as to reduce the hardship of the appointment of the curator. And my lady, more than that, the rules of this tribunal give the respondents a ready opportunity in the event that they experience any hardship pursuant to the curator orders being granted today, to approach the tribunal directly, to vary, to rescind, or to amend the terms of the appointment of the curator. So this is not a situation where, were this order to be granted today, it would last for all time without any consideration for any hardship that may be experienced by the respondents. Were that to eventuate, Rule 27.3 permits them to approach the tribunal and make out a case for variation. My lady, the last vestige of opposition to the curator's appointment from the respondents is that they complain that they will be liable for the costs of the curator. Well, we submit that there are two answers to that. The first is that if the curator order is justified on the grounds that I've submitted to your ladyship, it clearly is, then the cost should be borne by the respondents. It is their conduct that brings us before you today. It is their conduct that requires the value of those properties not to be diminished so that there can be proper recovery in due course. And it follows that should this interim interdict remain in place and should it be confirmed in due course, the cost that will be incurred should be for the pocket of the respondents. But my lady, there is also a second point. If the respondents maintain the property and its value, that will concomitantly reduce the costs occasioned by the appointment of the curator. If bonds are paid, if municipal services are paid, if the property is generally maintained, that will reduce the work that is required to be done by the curator. And so the respondents have it within their own powers to keep those costs as low as possible. My lady, those are our submissions in relation to the curator. And so with your leave, I'd go to the third and final part of our argument today.
I'd like to engage you on this question before you move to the next point. What stood out for me when I read Van der Merwe in relation to the SCA's approach in that matter is the importance of giving effect to the purpose of a preservation order, as opposed to the requirements you outlined.
Yes.
Because the reason why the SCA held in that matter that it's necessary to appoint a curator bonus was because SARS had satisfied it that the tax affairs of Ms. Van der Merwe had to be investigated.
Mm-hmm. Mm-hmm. Indeed, my lady.
When one considers that factor, then if I were to apply the test that you set out as applied in Van der Merwe, that test becomes too high in matters of this nature, because the purpose of a preservation order here is not to investigate the affairs of the respondents, but essentially it is to give effect to the preservation order. Is that not so?
Indeed, my lady, and I'm indebted to you for that input, because it is in part why I began with the purpose and the scheme of the rules. But I don't want to be misunderstood in having set too high a test. So if I may just engage on why the two can still work together. My lady, the purpose is certainly to ensure the proper preservation of the property to achieve recovery in due course. But it's in a sense with that backdrop that one asks, is there a legitimate concern on the part of the applicants, and will the appointment of a curator meet that concern? We say if you ask the question with reference to the purpose, the answer must overwhelmingly be yes. We are not, my lady, with respect, you're correct, in the investigative stage. Investigations have been done. The product of those investigations is the application before you. There is a real risk, we submit on these papers, that but for the intervention of a curator, which is appointed to protect preserved property, there will be a risk of a diminution in value over the course of these proceedings. And quite frankly, the applicants who are on the receiving end of unlawful activities perpetrated by their erstwhile employees should not have to suffer that diminution of value. So, my lady, we submit that those questions can be answered with proper reference to the purpose underlying the preservation of property in these proceedings.
The second issue that I need to converse with you is the question of the costs of the curator. And I'm asking myself whether one shouldn't draw a distinction at this stage of the proceedings between the costs of maintaining the property's value and the curator's fees. Because if there's no case against, if the applicants do not succeed ultimately against these respondents, why should they be settled with the curator's fee? So I think that distinction should be brought. The costs of maintaining the value of the property, ordinarily, they bear those costs.
Yes.
Property. And the costs of the curator bonus should be preserved. The fees of the curator bonus should be preserved at this stage. Reserved for later determination.
My lady, I would like to take an instruction on that, but certainly we will take very seriously that proposal. I can see no difficulty with it in principle, but if I may just return in reply with our position on that.
Okay, thank you.
Thank you, my lady. If I may then move to the pension order. Now, my lady, it's again important to stress at the outset that the pension order, like the curator order and like the preservation order, does nothing more than preserve the status quo. The fund is currently not paying out pension benefits to Mr. Lebelo. And all that the pension order does is to confirm on a temporary basis that it is not required to do so. Now, despite that seemingly clear objective of the pension order, the respondents oppose its grant essentially on the basis of the following argument. It goes like this. If the applicants are legally entitled to withhold the pension benefits, then the applicants don't require an order from this tribunal to that effect. My lady, you'll find that beginning to be introduced at paragraph 8 of my learned friend's heads of argument, but it's a theme of their opposition. My lady, our first response to that retort is that it doesn't properly understand the legal position. And for that proper legal position, my lady, you will have seen in our heads of argument, we drew the tribunal's attention to the helpful judgment of Justice Meyer when she was in the Supreme Court of Appeal in Highfeld Steel. What that judgment does is it analyzes an equivalent position, almost identical in its wording to the Transnet Pension Fund rules, but which appeared in that case in the Pension Fund Act. And what happened there was that the court interpreted that section of the Act to ask the question whether an employer was entitled to withhold the pension benefits prior to obtaining a court judgment to that effect. And Justice Meyer determined on a purposive analysis of the relevant legal provision that it would be entirely impractical and defeat the purpose of that act if employers were required to obtain court orders before they'd even been able to undertake the investigations necessary to uncover the misconduct that they were concerned had been perpetrated by their employees. And so what she holds at the level of interpretation is that there is a period of time where the Act, and we say the rules in this case, will accommodate a withholding of pension benefits while investigations to unearth the extent and detail of the misconduct are undertaken. But there is a point in time when those investigations will come to an end. And the rules in this case and the Act in that case do anticipate the need for a court order in due course to be obtained. So what we set out in our heads of argument is that in keeping with that approach of the Supreme Court of Appeal, Transnet has followed its guidance. It conducted an investigation, first itself, then referred to the Special Investigating Unit, and the culmination of that process is precisely the proceedings that are now before this tribunal. It is appropriate in those proceedings that the applicants then seek the very order that the Transnet Pension Fund rules refer to and which the Act referred to in the case of Highfeld Steel. We submit that the applicant's approach is not only consistent with the law, it is what the law requires. So the only remaining question must be, we say, whether that relief should be granted now and should be granted on an interim basis. The respondents resist that vehemently. They say there's no reason to give that order now because there's no threat of harm. Well, we submit that there are two reasons to give it now, and I'll deal with each of them in turn, if I may. The first is that Highveld Steel itself is authority for the proposition that orders to protect the status quo pending the recovery or damages action can appropriately be granted in a given case. The facts of Highveld Steel worked a bit differently to these facts because there it was the employee who sought to obtain through court order a payment out of his benefits. But what the Supreme Court of Appeal did in the end was to preserve the status quo and say that that application would have to be pended to the end of the damages case that had been instituted by the employer. So it is a recognition that it can be appropriate in circumstances to preserve the status quo pending the outcome of the proceedings for recovery. So we say at the level of authority, there is authority for this type of order being issued in the process that will arrive eventually at a recovery order if the applicants are successful. But secondly, we have set out in detail in the founding affidavit the escalation and the agitation that Mr. Lebelo has embarked.
You probably didn't. Sorry, Miss.
Yes. Oh, my lady, I'm not hearing you right now.
I think there's an interruption in the network because.
Yes. Let me check mine, and I can now hear you.
Yes, I think the network is.
My lady, unfortunately, you
become unstable. Can you hear me now?
I can hear every so many words, my lady. Apologies.
Can you hear me now?
Yes, that is improved.
Okay.
Thank you, lady.
Ms. Hofmeyer, let me allow you to finish arguing this point because I hear you loud and clear. Can you hear me?
Yes, I can.
Okay. Just continue.
Oh, my lady, I've lost you again, unfortunately.
You're arguing because I hear you loud and clear. Then I can hold. Yes, I'm saying continue arguing. I'll hold off what I needed to put you right up to the end. Hopefully at that point the network has become more stable because I hear you loud and clear. So you can continue.
Thank you, my lady. I wonder if it might be helpful for me to go off video, whether that
Can
would
you hear me now? Mr. Duplessis, can you hear me?
Yes, my lady, I can hear both of you.
Thank you. My lady, let me continue then. I just thought it might be useful if I went off my video to assist with the bandwidth. Should I maybe do that?
Seems to be on. You can. Okay. Mr. Duplessis, perhaps you're the one going off the video.
Yes, I've switched my camera off, my lady.
Mr. Duplessis should be the one because he's not addressing me.
Yes. Let's have. Thank you, Mr. Duplessis. We're indebted.
I can still see.
I think Ms. Hofmeyer, my lady said that you could proceed. She can still hear you, so you can proceed. If there's a problem and the ladyship tells me you can't hear, I will just inform you of that.
Thank you. I appreciate that. It seems strange that Mr. Duplessis has the best reception. So I'm somehow in the second position there. But my lady, I'm happy to continue. And if at any point you don't hear me, I'll await for you to alert me to that. Thank you. My lady, I was dealing with the issue of why now? Why grant this order at this stage of the proceedings? And I said that there were two reasons to do that. The one is that an equivalent position was adopted in Highveld Steel. What happened there was the employee had sought an approach to the courts to require his pension to be paid out. The employer had sought to intervene in that case, and the outcome before the SCA was to pend that whole determination to the end of the damages case that had been instituted by the employer. We say that is akin to what is being sought here, that we pend, we preserve the position where pension benefits will not be paid until the outcome of the recovery proceedings that will be brought in due course. And we say if the tribunal were to adopt that approach, it would be in good company, because that is the outcome that was adopted by the SCA in Highveld Steel. But the second reason, my lady, is at the level of fact. It's about what these papers set out has been done by Mr. Lebelo as he has agitated and escalated his claims to be entitled to these pension benefits. I want to deal with those facts in a moment, but I first want to emphasize a point of some importance. It is no part of the respondent's argument before you today, at least as we've seen it in the heads of argument, to suggest that Transnet's understanding and the applicant's understanding of the legal position is incorrect. That carries some significance in these proceedings. If we are right about the law, it means that Transnet does not have an obligation while it is conducting this investigation and did not have it to pay out the pension benefits. And what we say about that law is, having concluded the investigation, it must now proceed to obtain a court order to that effect. That is why it comes before this tribunal and seeks to preserve the status quo on an interim basis. Now, despite having no argument to suggest that that articulation of the law is wrong, Mr. Lebelo has taken it upon himself over the last many years to agitate for the payment of his pension benefit, despite the serious allegations of misconduct against him, and despite the investigation that he was told was being undertaken. He went to the principal officer of the fund. He even laid a complaint before the public protector. And what the papers show you, my lady, is that that investigation is underway, it is continuing, and it is in that context that when these proceedings were brought, Transnet and the SIU knew full well the lengths that Mr. Lebelo had gone to engage the public protector on this, to claim her intervention so that pension benefits could be paid out to him despite the ongoing investigations. And we say that it is that conduct which precipitates the need for a preservation order. By preservation, I mean to preserve the status quo, so that there are not funds paid out to Mr. Lebelo, so that the objects of this act can be properly achieved if Transnet and the SIU make out their case for recovery in the end. Now, my lady, despite all of those facts and that backdrop, the respondents still say that you should not grant an order today to preserve the status quo. And with respect, I must say that their argument on this is nothing short of remarkable. It goes something like this. The first proposition is that this tribunal should not grant an order which Transnet is legally entitled to, an order which confirms the legal position that the respondents do not dispute is the legal position. So on the one hand, they say, despite not disputing the law, this tribunal should not grant an order to confirm that position. And then secondly, they go further. They say that despite a full investigation having been conducted and completed, the misconduct that it takes hundreds of pages to set out in this founding affidavit being presented, Transnet should not obtain an order from this tribunal today. Why? Because if in due course the public protector directs that these pension benefits must be paid out to Mr. Lebelo, it's all okay. Transnet can incur further legal costs and run off to the High Court to review the public protector's remedial action. My lady, the bottom line of the respondent's argument is that the state should pay more money to pursue more litigation in the event of a public protector remedial action that requires a payment of pension benefits, which they don't dispute would be a wrong position in law for her to adopt. My lady, I describe the argument as remarkable. It is also grossly wasteful. There is no good reason proffered by the respondents for why the public purse should be burdened with further litigation in the event of a remedial action from the public protector that would be at odds with the legal position. We submit before you today that the law recognizes a period of time within which investigations can be conducted and pension benefits withheld. But once those investigations conclude, it is incumbent upon the employer to obtain the relevant court order, and these proceedings are precisely the proceedings in which that application is made. And we say we seek that order on an interim basis to preserve the position so that proper recovery can be made at the end of the day. My lady, those are our submissions in relation to the pension. I do still want to conclude, to sum up, but I understand that you were going to have some questions for me on this aspect.
Yes, what I wanted to put to you is that you probably didn't come across the tribunal's judgment in Hlachwayo, where Highveld still was applied under facts similar to the present ones.
Yes.
And in fact, it's not necessary for the investigation to be completed for the SIU or even an employer to approach the tribunal. Even when the investigation is in process, that's what Highveld still says.
Yes, I'm indebted, my lady. We had not come across that one, but certainly if it can come earlier, it can certainly come at the end, would be the force of our submission today.
What the respondent seem to be complaining of is that Mr. Lebelo has not been able to access his pension fund, and there's no reason to believe that he will be able to, because he's not been able to. That's how I read.
Yes.
Race.
Well, if that is so, he should indicate that he has no intention of continuing to motivate for payments of the pension. My lady, if they are saying there's no risk, well, then there is no hardship for the order to be issued. The order does play an important role. It protects and preserves the position pending the recovery action. And it also plays an important role vis-a-vis the investigations of the public protector. That is why those investigations and details are set out in the founding affidavit. This is not just a case where it's employer-employee debating the merits of whether the pension should be paid out now. There's a third party, a Chapter 9 institution that's been engaged by Mr. Lebelo, who is being encouraged to intercede in these events. And in those circumstances, we submit it is appropriate, it is necessary for this tribunal to preserve the status quo. The law entitles these pension benefits not to be paid out until this recovery case is finally resolved. That is certainly what Highveld Steel held. We say we should get an order from this tribunal on a provisional basis today to maintain that status quo. And there is no case for hardship on the part of Mr. Lebelo that's been presented. Why? Because he doesn't dispute the legal entitlement of the withholding of those benefits. So, my lady, we submit that there is an ample case that has been made out in the founding papers, both for the curator order and for the pension order. Those orders do no more than preserve the current status quo. They do so on a temporary basis. And if in due course at the return day, the respondents are able to present to this court, this tribunal, reasons for those orders to be discharged and not confirmed, they will have their full procedural entitlement to do so. So, my lady, we concluded our heads of argument with the relief that the applicants seek before you today. I'll just run through that in the interests of summarizing my argument. My lady, you'll find it at page 19 of the heads. What we say there is that the following relief is sought by the applicants today. That pending the return date, the preservation orders that have been agreed by the respondents be granted, and in addition to them, the curator and the pension orders be granted for the reasons given. That costs of the application be costs in the cause, and then we set out the timetable for the further prosecution of the matter to the return day on the agreed timetable between us and our learned friend. Of course, that is subject to any directions given by the tribunal for its convenience. Thank you, my lady. Those are our submissions.
Thank you. Thank you, Ms. Mayor.
As it pleases you, my lady. I need to, before I start, also put this application or this part of the application in context. My learned friend argued quite correctly that your ladyship should look at the application in the context of the founding papers. Now, obviously, my lady, the respondents did not have the opportunity to file an answering affidavit, and your ladyship should accept, for purposes of this application, the allegations as contained in the founding papers. It is an interim order. The only issue, my lady, and it's my learned friend maybe incorrectly stated that the respondents are vehemently opposed to these orders being granted. That's not the case, my lady. We say that the only argument, my lady, is that the founding papers do not make out a case for any of these orders to be granted. And we set that out in our heads of argument. But let me just say this, my lady, also, that your ladyship should or will remember, will bear in mind that on Monday, when the case management meeting was held, the respondents provided certain undertakings, and your ladyship invited the parties to then see whether they couldn't agree on a draft order or an interim order in light of those undertakings. Those undertakings, my lady, were contained in the draft order presented to the tribunal by the respondents. The applicants then wanted to also include these two further orders in the draft order, and that's the reason that we're here. It's not a case where there's some mala fide objection is taken to these orders, or that the respondents for some reason are strenuously opposing the granting of these orders. And I will refer your ladyship to the authorities and to the founding papers to say or to show your ladyship why the respondents oppose these two orders to be granted at this stage. And obviously it doesn't result in the applicants not being able to approach the tribunal at any stage thereafter, because if I understand Rule 27 correctly, it says that the tribunal shall at any time grant certain orders. So it doesn't mean that if they, on the papers, haven't made out a case at this stage for the granting of these orders, that they're not entitled to do so, or to bring a subsequent application or a supplementary papers in due course, even before the Rule 9 or the return date for these orders to be granted. I will start, my lady, with the appointment of the curator bonus, which was what my learned friend started with. I had it the other way around in my heads of argument. But, my lady, the first point is that although Rule 27 provides for the court to be, or for the tribunal, or grants a power to the tribunal to grant an order for the appointment of a curator, it must be implied, and I don't think my learned friend has any problem with this proposition, that the proper case must be made out on the papers for such an appointment. They cannot expect the tribunal to make such an order if no case has been made out on the papers. So the only issue, as far as the appointment of a curator is concerned, at this stage, my lady, is whether the applicants have made out a proper case on the papers. And my learned friend also referred to the tribunal's power to make any other order which it deems appropriate. And I take it that that's a reference to Section 8(2)(b) of the Act, which provides for that. But that can only be done in certain circumstances. With due respect, and I'll refer your ladyship to the authority in that regard. Although no reliance was placed by the applicants on that section, they only rely on Rule 27 of the tribunal's rules. Now, my lady, if one looks at the allegations that are made, and my learned friend relies quite heavily on the background and on the investigation that was conducted and on the conduct of the respondents in submitting that on the papers and in the context of the papers, a proper case was made out. But, my lady, if one looks at that context, in the first place, the first investigation was completed not by the SIU or by the first applicant, but by an independent party, it seems, was completed in 2017 already. The first respondent resigned from the employment of the second applicant in 2018. Now, what has happened between, and he's been aware on their version of the investigation that was pending from that time until now. So what has happened between 2018, from the time that he resigned in respect of the property, until now, that would justify the applicants to an order for the appointment of a curator? And my learned friend says that over and above the allegations contained in paragraphs 28, 29, and 30 of the founding papers, she relied on the allegation that was made in paragraph 265, and I will deal with that in a second, my lady. But nowhere on these papers is there an allegation that these respondents will do anything to diminish the value of these properties. They make the general propositions in paragraph 29, for example, and this is also one of the allegations relied upon by the applicants. The deponent to the affidavit says the following: in the SIU's experience, he doesn't even say that it is in his own experience. He says in the SIU's experience, it is often necessary to appoint a curator. In other words, it's not always necessary. It's often necessary. Now, if it's often necessary, what are the facts of this matter? Why do you say in this matter that the appointment of a curator bonus is necessary and that you need it on an interim basis? And that your ladyship will find nowhere, except maybe if one can then go to paragraph 265. Unfortunately, my lady, my papers aren't indexed and paginated, so I referred only to the paragraphs and to the page numbers as they appear at the bottom, the typed page numbers. It's page 155 of the founding papers. Now, the allegation is made that there's a real likelihood that the respondents will not preserve the property and or money. Now, as far as the preservation is concerned, we already, my lady, have the undertakings and we have the draft order proposed by the respondents, which would take care of any selling or alienation or encumbering of any of these immovable properties. So it seems the only issue that remains, as far as the appointment of a curator is concerned, is whether any of these respondents would stop payment of municipal rates and taxes. Firstly, that's something that my learned friend repeated often in her argument. firstly, and secondly, whether the maintenance that these properties need would continue, and whether there would be any reason for them to stop maintaining these properties properly. And if one looks, my lady, at the allegations that's contained in that, he says in paragraph 265.1, both Mr. Lebelo and Mr. Mashamba have conducted themselves dishonestly in their dealings with Transnet. Well, that on its own one cannot conclude from that allegation or any of the allegations that follow that even if it's correct that they conducted themselves dishonestly, that it would follow from that they wouldn't maintain the properties pending the outcome of the action to be instituted or of the return date. They have both actively sought to conceal their secret profits. In the case of Mr. Lebelo, this took the form of receiving property through a family trust vehicle, etc., etc. None of these allegations, my lady, would justify the appointment of a curator or would or makes out a case that there is a threat from any of these respondents that they would not maintain these properties properly, or that they would cease paying the municipal rates and taxes in the interim. Mr. Lebelo has been actively seeking, that deals with the pension fund, which I will deal with now. And then Mr. and Mrs. Mashamba, Ms. Mashamba have also recently disposed of the Diepsloot and Beverly properties and transformed these ill-gotten gains into a new property for themselves. Well, also, as far as that's concerned, there's no allegation that the disposal of their old property or properties and the obtaining of a new property was done for any mischievous purpose, or that it was done in order to dissipate their assets with the intention to make any order granted by the applicants eventually worthless. So, my lady, on these papers, there are just no allegations. There's no allegation as far as diminution of value is concerned. There's no allegation that there's a threat that would justify the order sought by the applicants. And I refer to your ladyship my lady, in paragraph 23, that the allegations that are made in the founding papers are non-specific and general in nature, without explanation as to what had transpired in other cases that would justify the applicant's fears, because he says in the SIU's experience. Now, what is that experience? That should be explained to your ladyship. And your ladyship cannot take judicial cognizance of other matters without having regard to this application. That should have been set out in this application. And my lady, then no allegations are made in respect of the risks that these respondents pose to the non-maintenance of the relevant properties, and no information is provided in respect of the 8th respondent. That's the other point that I want to make. If one looks at the 8th respondent, which the applicants want to, or the tribunal to appoint in this matter, what do we know of the 8th respondent on these papers? We know nothing. The 8th respondent can be anybody for in all intents and purposes. My learned friend didn't address this issue at all in her argument. So on what basis, even if the tribunal finds, if your ladyship find that that a curator should be appointed, why should the 8th respondent be appointed, and why are the applicants entitled to an order for the appointment of the 8th respondent in this matter as the curator? We know nothing, as far as I could ascertain, about the 8th respondent on these papers, my lady, and we've made that point in our heads. As far as the costs are concerned, my lady, the issue as far as costs are concerned is just was mentioned in the heads because of the fact that the applicants complain about a potential review application against a ruling by the public protector, and that extra costs would be incurred, and that they would have to incur extra costs as far as that's concerned. But on the other hand, they don't have a problem in incurring extra costs for the respondents in this matter by the appointment of a curator. My lady, the submission is just this. On the papers, no case is made out for the appointment of a curator. Firstly. Secondly, the respondents, by providing the undertakings and by agreeing to the draft order, which we say should be made in order of court of the tribunal, have shown that they are bona fide. We haven't been, or the respondents haven't been requested, my lady, to provide any further undertakings. But on these papers, there's just no allegation or a case made out, even a prima facie case, that these respondents would allow the properties to diminish in value pending either the return date or the outcome of an action to be instituted. So on that basis, we say, my lady, and if I may refer to the Van der Merwe matter, and I've taken note of what your ladyship said, that the Van der Merwe matter set out too high a test for the appointment of a curator. That may be so, my lady, but the point that I wanted to make in referring to that matter was it, in that case, the proper case was made out by the applicants for the appointment of a curator. And I'm not saying that it should be because the appointment in this case should be to investigate certain things or for the collection of taxes. Obviously, that matter dealt with a totally different statute. But a proper case was made out, and that is the importance of the Van der Merwe decision. The wording of the enabling legislation in that matter are the same as the wording of the rule of Rule 27 in this matter. In other words, it also said that a curator may be appointed in certain circumstances, and the Supreme Court of Appeal discussed whether the court or quo should have appointed a curator on the basis of the allegations contained in the papers, and found that it should have, and that's why the Supreme Court of Appeal then made the appointment on appeal. My learned friend says that this matter supports, or the decision supports, the applicant's case because your ladyship should find that the applicant's concerns are legitimate. Well, on what basis is it legitimate? Why are there concerns in the first place? The concerns that they have, my lady, is because of the conduct of the respondents, which was found in the investigation. But why should, even if all of that is correct, and your ladyship should accept that for the time, for present purposes, why should that result in a fear or a concern that the respondents would allow the diminishing in value of these properties, which are properties that they live in at the moment, my lady? So for that, sorry, my lady.
Sorry, please continue.
Yes. So for those reasons, my lady, I submit that the applicants just are not entitled to an order for the appointment of a curator in the interim, or and more specifically for this curator that they want to appoint. Then, as far as the pension fund is concerned, my lady, exactly the same issue is relevant. We also say that no case has been made out for an interdict. In fact, if one looks, my lady, and I'll address the decision by Her Ladyship, Ms. Justice Meyer, in a second, the Highveld Steel decision. But if Your Ladyship looks at paragraph 257 on page 152 of the founding affidavit, the applicants make the following allegation. Transnet is therefore entitled to withhold the pension payments from Mr. Lebelo pending the outcome of the action that it will institute following this application. That allegation on its own, my lady, makes it totally unnecessary for them to obtain an interdict against the pension fund for any payments made by the pension fund. This order that they want, my lady, as far as the pension fund is concerned, is not an order that is covered by the rules and the Act in this matter. And they've conceded as much, and that was the reason that the application was served on the respondents. It wasn't brought as an ex parte application. So it falls outside the ambit, my lady, of the Act and of the rules in terms of the Act. It's an anti-dissipation interdict. It's an interdict that is extraordinary. It's an anti-dissipation interdict over and above the fact that they don't need that on their own version. They don't need an order because they say that they're entitled to withhold. And for present purposes, we accept that. My learned friend says, well, if you accept that proposition, why do you then are you against the granting of an interim interdict? We say, my lady, that the applicants must show the requirements for an interim interdict. Two of those requirements is that there must be a reasonable apprehension of irreparable harm, and the other one is that there should be no alternative remedy. And we say none of those requirements are met in this case. And for that reason, they cannot just go tell the tribunal.
Network has become very unstable. I'd like to adjourn for about 2 minutes to get on an alternative network.
As should we reconvene at 11:30?
No, just 2 minutes. I'd like you to complete your argument before we take the tea agenda.
Oh, I see. Yes.
So just 2 minutes.
Well,
I just need to sort
yes,
out my network.
Thank you, my lady.
Yes, is this better?
Yes, as a court pleases. I can see your ladyship a lot better than before.
Can you hear me much better?
Yes, my lady.
Thank you.
Yes, thank you, my lady.
My lady, the Highveld Steel matter, with due respect to my learned friend, is not authority for the proposition that an employer or a pension fund can obtain an interdict in these circumstances. What happened in that matter, as my learned friend quite correctly explained to your ladyship, is that it was an appeal against employee's application to obtain the benefits of the pension fund, meaning the outcome of an action. And the court said on page 6 of C the following: it seems to me that to give effect to the manifest purpose of the section, with a reference to the Pension Fund Act, its wording is interpreted purposefully to include the power to withhold payment of a member's pension benefits pending the determination or acknowledgement of such member's liability. The funds therefore have the discretion to withhold payment of the respondent's pension benefit in the circumstances. I dare say such discretion was properly exercised in view of the glaring absence of any serious challenge to the detailed allegations of honesty against the respondent. So, my lady, there was no interdict granted because an interdict wasn't necessary. What the SEA found was that the pension fund had the discretion, and in this case, this is conceded by the applicant in the application to a. So where is the threat, my lady? Where is the reasonable apprehension of harm? That is one of the requirements for an interim interdict in this respect. It just doesn't exist on these papers and on these facts, and for that reason, the applicants aren't entitled to an order against the pension fund, because on their version, and it follows from what they are saying, my lady, that whatever the first respondent does and whatever attempts the first respondent makes to try and obtain these pension benefits, you will not be successful with that. And there can be no reason why the public protector, even if it was escalated to the public protector, why the public protector would try to force them to pay out the pension benefits. And they don't say that there is such a risk or such a threat. And for those reasons, my lady, also we say that the applicants aren't entitled to such an order. In paragraph 14, my lady, of the heads, I refer to the fact that such an interdict is an anti-dissipation interdict, and because it does not fall in terms of the ambit of Rule 24, they have to show all the elements of an anti-dissipation interdict before they will be entitled to that. One of the elements, my lady, as set out in the Knox-Darcy case and in various subsequent cases, is that they must show that the debtor or the respondent has the intention to dissipate the assets with the intention to frustrate any eventual judgment that they would obtain against the respondent. That is one of the. You won't succeed with an anti-dissipation interdict in the High Court if you cannot show that on a balance of probabilities, or in this case, even on a prima facie basis. There is no such allegation, and there hasn't even been an attempt to show that to the tribunal. And for that reason also, my lady, we say that they're not entitled to such an order. So, my lady, the gist of the argument, my lady, is just this, that the undertakings provided by the respondents, as set out in the draft order provided by or given by the respondents, adequately protects the interests and the rights of the applicants pending the return date, and there should be no reason why why the orders that they currently seek will give them any further protection, or that they would need that protection. That's the first issue. The second issue is that even on the papers, we say that they're not entitled to any of these further orders because they haven't made out a case for these further orders. And, my lady, I've addressed the issue of costs. It's in your ladyship's discretion. But, my lady, if an order is granted as proposed by the respondents, then we say today's hearing was totally unnecessary. We already gave those undertakings on Monday, and we provided both the applicants and the tribunal with a copy of the draft order that we proposed, my lady. And for that reason, we then say that they should be ordered to pay the costs of this hearing, my lady. Those are my submissions, my lady. I have nothing further to add.
Mr. Du Plessis, in Highfell Steel, my reading of the judgment is that the issue that the Supreme Court of Appeal had to determine was to interpret the relevant provision in Section 87 of the Pension Funds Act, because in terms of that section, a pension fund could only withhold payment from a member. The member agrees with the member's agreement, or as ordered by the court. And the question was, under circumstances where there's still an investigation or pending proceedings, and there is no agreement by the member to withhold, but an applicant or employer has not yet obtained a court order, may pension funds be withheld under those circumstances? And that's exactly the scenario we're dealing with here. Is that not so? That's exactly the scenario we're dealing with here. Mr. Lebelo has not given his consent for the funds for his pension benefits to be withheld, and there is no court order establishing his liability against Transnet. So the funds, even notwithstanding the fact that Transnet pension fund has not paid his pension benefits to him, the funds remain vulnerable. He is still persisting in having the funds withdrawn, and hence there's a pending investigation by the public protector.
Yes.
So funds remain vulnerable.
No, my lady. Sorry, what the Supreme Court of Appeal said, my lady, is that that Section 37 of the Pension Fund Act, and in this case, the case before us today, the applicants also referred to the wording of the pension fund, which is similar to.
It's similar, yeah.
Similar. It also says they can deduct if there's a judgment or a consent.
Yes.
But the Supreme Court of Appeal said it must be those words must be interpreted widely to also include the period before such an order is granted. In other words, before they obtain a judgment. So they have this case is authority, my lady, for the applicant's position in this matter, that they are entitled to withhold the funds pending a judgment being granted. And it's not authority for the fact or for the proposition that the applicants are entitled to an interdict in the interim. Because if they say, we have the right to withhold the funds pending a judgment to be obtained, why would they then need an interdict? And in this case, my lady, in the Highveld Steel matter, no interdict was granted. The court said that
here they are relying on the pending investigation by the public protector, and they are saying if the public protector determines that Transnet pension fund must release Mr. Lebelo's pension benefits to him, then Transnet remains exposed, because then you have to take the public protector's determination on review. They are here now and they need to secure their rights now.
Yes, my lady, I can't take that further. All I can say is this, my lady, that they must show that there is a threat, at least prima facie threat, that the public protector will make such a ruling, or that such a ruling is imminent. What they said on their papers, my lady, is that they wanted to have a meeting with the public protector in order to explain to the public protector their position and the reason why they are withholding the funds. That meeting has not been held. But that's the furthest they go. They don't say, my lady, that the public protector, or that there's any indication that the public protector may direct that the funds be released in the interim. That's the first thing. The second thing is, even if the public protector does make such a ruling or give such a direction, they have an alternative remedy. And my learned friend says, well, why should they incur the extra costs? Those costs, my lady, will only be incurred if the public protector, for some unforeseen reason or some unknown reason, directs them to pay out the pension fund. The probabilities of that happening, my lady, I'm not even sure that they made out any probability on these papers. So those are the only submissions that I can make as far as that's concerned.
Okay, and then the test that you are proposing I should follow in determining whether a case is made out for the appointment of the curator bonus. You heard the point I engaged Ms. van der Merwe on. And you are saying a proper case has not been made out here, and you rely on the judgment in van der Merwe. But you correctly point out that that judgment was concerned with an entirely different legislative framework from what we are concerned with here.
There are many, probably 5 or 6 pieces of legislation that have similar provisions that says that either the court or a tribunal has the may appoint a curator under certain circumstances, and they all read basically the same. So, my lady, the fact that there was reference to another piece of legislation does not detract from the issue that a case must be made out in the papers that there is a threat of a diminution in value of these properties, and we say no such case was made out.
So here, Mr. Du Plessis, having regard to the purpose of the SIU Act, which is fundamentally to recover monies lost to the state under various circumstances.
Yes.
The circumstances alleged here being part of those. Doesn't the threat of civil proceedings to disgorge profits secretly end from an employer, or to seek damages as a result of breach of employment duties, having regard to the allegation that these properties were actually acquired using the very same secret profits that Transnet and the SIU is seeking to disgorge, introduce a very real risk of diminution when the respondents know that they are facing the risk of losing these properties?
Well, my lady, that is exactly the type of general proposition that we say cannot be used as the test. We say there must be some fact, particular to this matter, which would justify such a conclusion to be drawn, and we say it just doesn't exist in this case.
Thank you.
As a court, please.
Ms. Hofmeyr.
Sorry, my lady, there was just one thing. Your ladyship also discussed with my learned friend whether if a curator is appointed, whether your ladyship shouldn't reserve the costs of such a curator pending the return date. That would be my alternative submission, my lady. If your ladyship...
No, I
the fees, yes, the fees.
But when you didn't engage with that, I thought you were content with that suggestion, just reserving the fees.
Yes,
but road lines would continue paying the maintenance costs.
As it pleases you.
Yes. Okay.
Thank you, my lady. My lady, I'll deal briefly in reply with the 2 main themes on the curator order and the pension fund order. If I deal with the curator order first, I did indicate to your ladyship I'd come back to you in relation to that reservation of the curator's fees. The applicants have no difficulty with that and suggest that that would be an appropriate order pending the return day, that those fees are reserved subject to confirmation on the return day, certainly. My lady, then if I can deal with this theme, which your ladyship actually picked up on with my learned friend towards the end of his argument. This theme that there's no adequate allegation in the founding papers to support the curator's order. My lady, you heard us in our main argument, and with respect, my lady, you in a sense put those concerns to my learned friend fairly in the debate with him. When one asks whether it's appropriate to appoint a curator in this case, one has to ask that question against the purpose of this legislation and the role of this tribunal in the pursuit of recovery of funds that were misappropriated from the state. And my lady, with respect, and this is the point that we made in the heads of argument and Mr. Turon makes in his affidavit, when there is a threat down the line of civil recovery and forfeiture of property, it is axiomatic that there is a risk that the value of those properties will diminish over time, because the incentives of the property owner are implicated by that threat of forfeiture. They don't operate in the world that they operated the day before these proceedings were brought, when there was no threat that they would lose these properties. Once there's a threat that these properties are going to be that which is used towards a recovery in due course, the normal incentives diminish. The normal incentives to keep paying your bond and keep up maintaining your property just are not what they were the day before. And my lady, my learned friend says there needed to be more in this affidavit. Well, I thought as he was saying to that, what sort of more was needed? Do the applicants before this tribunal have to go back over past bank statements and say, oh, there was one occasion when a bond repayment was late, and that means that there's a risk? Of course, that type of fact not only isn't required, but it's not appropriate. The risk arises because these proceedings are being brought. And in pursuit of the purpose of this act, it is appropriate to protect the position for recovery in due course. And one of the ways in which that is done is a curator is put in place simply to ensure that what is needed to be done to maintain the value of the property is done.
Yes. That's why I'm very concerned about the approach in Fundamental, because in Fundamental, the court looked at the prior conduct, the prior conduct of
the father and Ms.
The father and Ms. Fundamental as taxpayers. That test is too high.
My lady,
focusing on the purpose.
My lady, with all due respect, I see that. I had not seen that on my first read of the judgment. What I focused on was what, if you apply it in this context, seems opposite. Is there a legitimate concern, and will a curator address that? We say there is a legitimate concern, but it's a product of the purpose and the statutory scheme. But my lady, I'm indebted to you, because if what my learned friend tries to derive from Fundamental is that you have to put up these specific facts in relation to the threat that they will do something, they won't maintain the garden, for example, or they won't pay the bond. You can never have those facts. You wouldn't be able to acquire them as the SIU or the applicants that come before this tribunal. So, my lady, in that respect, I'm indebted to your ladyship for this direction. If that is what he is making of the Fundamental case, it is inapposite. What is required in this case, and no more, we submit, is that there is a legitimate reason to be concerned about diminution of value. And we say that reason arises the moment these proceedings are instituted. Because hanging over these properties, the respondents may never reclaim properties if recovery runs to its end and the applicants are successful. And when that event occurs, the normal incentives change. And we say that that is adequate reason to put in the protection of a curator. My lady, the last point on the curator is my learned friend's concerns about this specific curator. My lady, I can be frank, by the time these papers were issued, we had not been able to obtain a letter of consent from the curator together with his resume. That, of course, should have been obtained and can be obtained and will be provided if that is necessary. But my lady, I suggest that's not, because this tribunal itself, in one of the orders that we included in our authorities bundle and was referenced in our heads of argument, has previously appointed this very entity as a curator in a previous case. My lady, that was the case of the SIU versus Yokulinda. It's case number GP/01/2022. It was an order granted earlier this year in February. And my lady, if you have received our authorities bundle, and just for the benefit of my learned friend, you'll find the appointment of the curator there at page 99 of those authorities. So there would be no reason to be in any sense concerned about the appointment of this curator in these circumstances. My lady, if I may then move to the pension fund argument, and there are really three points I'd like to make here. My lady, with respect to my learned friend, he misunderstood my argument, albeit briefly given on the first day that we convened. He seems to think that we had said that there isn't a legislative basis or a regulatory source of the power for this tribunal to grant the pension order. That is no part of our submissions. This tribunal is empowered to grant the pension order because it is empowered under Section 2A of the SIU Act to grant a range of orders, including interdictory orders. And this is an interdict.
Sorry, it's 8.2. 8.2. I actually forgot to debate that. Section 8.2. The tribunal has authority specifically to grant an interdict. Yes.
Indeed. That is confirmed again in Regulation 5.2E, where amongst the relief that can be granted is interdictory relief. The only point I made on Monday, I think it was, when we convened, is this is not a Rule 24 interdict, because a Rule 24 interdict requires us to show that the property that is interdicted is the proceeds of unlawful activities. That is the only point that I made. And you'll be aware that under Rule 28, you can assume rule powers with reference to the rule where there is any gap that have been promulgated by the tribunal. So, at this point, there's no lack of underpinning power on the part of the tribunal to grant this order. It may grant interdictory orders that pursue the purposes of the Act, and to be given already. A hold on the pension fund pursues the purpose of this Act because it keeps a value sitting in the pension, which if Transnet and the SIU succeed in due course in their claim for compensation, can be deducted from the pension. My lady, the second point in response to my learned friend is he keeps characterizing this as an anti-dissipation interdict, but he overlooks the actual source for this order, and that is in the fund's rules itself. The fund's rule says, and we provided these, my lady, in the heads of argument at page 14, the fund's rules recognize the right of the employer to deduct from the pension compensation when certain acts of misconduct have been perpetrated by an employee and the employer in due course has obtained a judgment to that effect. So the basis for the interdict is as a precursor to that very relief that is recognized under the fund's rules. The only question you ask your ladyship today with respect is there need to preserve the non-payment of those pension benefits pending the recovery case and its conclusion in due course? And we say there's every reason to do so. My learned friend, and this is the final point I'll make in relation to the pension order. My lady, in your debate with my learned friend, you put to him that there's a unique feature in this case. It's the engagement of the public protector. And engagement makes translate as long as the investigation is continuing, for as long as it hasn't. And my response is direct, and exactly for some that the pension must be transferred. But that overlooks that it's the client agitating public protection order. He says he can't be given. Well, it's Lebello's own conduct that makes this challenge, that makes and before the tribunal today, we say this its position is not bound to the parallel process that Mr. Lebello himself has created. Maybe today, no basis today that these orders they refuse to do so, and that is what has necessitated today's argument. My lady, those are our submissions unless there are any further questions.
No further questions. Thank you very much for your assistance. I am reserving judgment. I'll hand out judgment fairly soon.
As it pleases you, my lady.
As it pleases you, my lady. Thank you.
The proceedings are adjourned.